think it might have an effect on future potential donors to the organization to know that their name, phone number, address, et cetera, could be disclosed as a result of the subpoena?
It certainly has not in this case. I take petitioner.
How do you know that?
So I take petitioner in their reply brief, in this case, to all but concede that there's not been any evidence of anyone actually being chilled by this subpoena over the 2+ years of litigation.
How do you get that evidence? Somebody comes in and say, I'm chilled. I don't want to reveal my name, address, phone number, et cetera, and here's my affidavit. That's not going to work, is it?
I absolutely think that that is something they could have pled here, but they did not plead it. And I think if you look at the declarations that they submitted in support of their motion for a preliminary injunction, I think it's the same problem. So if you look at the donor declaration, they submitted a declaration on behalf of anonymous donors. This is at Petition Appendix 174 to 178. There's no allegation of any prospective chill for any of those donors. I think the closest they get in this entire case, based on this factual record, to alleging chill is at Petition Appendix 177, this is the donor declaration, paragraph O, which says, quote, each of us would have been less likely to donate to First Choice if we had known information about the donation might be disclosed. But that's a backwards-looking statement of harm. It's not about prospective chill.
Really? I mean, we're going to now pick over the tense of the verb that they chose? I mean, they're saying if we'd known that this was going to happen, we wouldn't have given. Perforce, if it's going to be disclosed, we won't give. I mean, doesn't that just follow night from day?
We don't think so for a couple of reasons. First, this court's decision in Lyons makes perfectly clear that a backward-facing allegation of harm isn't sufficient.
I understand that when you're dealing with prospective harms, but that allegation seems to me, I mean, really, that's what this case turns on, is the tense of that verb.
I think that's the closest they get to standing. I do want to explain why we think it is particularly the case here that their backward-looking allegation really can't establish.
What if they had said, what if they had used the future tense? If this information is disclosed, we will not donate.
I don't think that would be.
That wouldn't be enough?
No, because that allegation that you noted is tethered to whether or not there will be disclosure. But I think the harms that they're identifying have to be tethered to the subpoena itself. I think this goes back to some of the colloquies earlier this morning about whether you can have standing based on the issuance of the subpoena from the moment of the receipt of the subpoena itself. If petitioner had alleged that there were chill harms, and those chill harms need to be objectively reasonable, but if they had alleged chill harms from the moment of the subpoena's issuance,
so
I think
they have to allege that in the complaint. They have to allege specifically in the complaint that donors will be chilled?
Yes, I think so. And they have to be chilled by the issuance of the subpoena.
So what's wrong with then, if the tense is what matters, what's wrong with paragraph P?
Yeah, so I think paragraph P suffers from the same problem. It says if our personal information is disclosed.
Yeah, that's
to
future.
The Attorney General. That's
right.
It's future, but it's about a future state court order. And
okay, all right. So really, it doesn't boil down to the past tense. It boils down to your argument about self-executing versus non-self-executing.
So I think that's
your assertion at the end of the day that because it's non-self-executing, there's no threat of chill.
Yeah, I think
so
just
really,
to be really clear,
we can get past these tense issues then, right?
Yeah, just to be really clear about this, if this subpoena were considered self-executing as a matter of state law,
I've got that.
You don't even need to get to chill.
I know. We're dealing now with, I think your argument ultimately has to be that non-self-executing subpoenas can never be enough. I think that's your position, because I think you're conceding that, okay, they've got the right tense in P. Fair?
So they've got the right tense in P, but they've got the wrong thing in their
Well, suppose
site
that they had the right thing. Suppose that they said, if there were a subpoena issued that even those, if there were a subpoena, even though non-self-executing, that were issued, because of the possibility that it would be executed on by a court, I would not contribute.
I think that would be sufficient to allege chill, but that's not necessarily enough by itself to get to that chill being objectively reasonable. So our position in this case is that they need to do two things. They need to allege that there has been chill. I think they fail at the outset on that metric. But they also then need to allege facts indicating that that chill, based on the issuance of the subpoena,
And that